Well, good afternoon. Lovely rainy Friday afternoon up here in Pretoria. Rian Kutsia from Fortis Proactive Defense Solutions. And today we will be discussing something that happened in the past week that's got everybody falling all over themselves. And I'm talking to Gideon Joubert Paratus down in Cape Town. And we will be talking about this latest proposed changes to the PSIRA, the private security industry regulations. Gideon, welcome and hello.
Thank you, Rian. Always good to be here. And it's a very interesting and highly relevant topic. And today I'm also wearing my South African Gun Owners Association hat.
Right.
So somehow we have managed to get to the tip of the sword on this issue alongside a couple of other people and have been
Okay.
first out the gates about it. So I'm quite proud of that, to be brutally honest. And it's
On
getting good
that
traction.
one.
And
Okay.
yeah, I think to start off with a bit of good news, I checked in with the people from Free SA this morning. They're the guys that
Mm-hmm.
are running the public participation campaign for this.
Yes.
They had more than 11,000 objections by late last night against
Oh,
this, which is good going.
that's good going.
Yeah.
That's good going. Gideon, let's kick off when we talk about the meat and bones of this whole thing. Um, One of the proposed amendments that I noticed would prevent security companies who are under investigation from issuing firearms to their security officers. So, I mean, I get that the aim is accountability, but what are the operational risks and the legal implications for such a company during a time when it's under investigation and now they can't issue firearms, um, and they're not yet found guilty?
So I'm going to keep it very short. The economic and commercial implications for a company suffering this kind of fate, so to speak, is to go out of business. And it's very simple why you'd go out of business. So um, there are mechanisms, existing mechanisms, extensive existing mechanisms, and we'll discuss this
Mm-hmm.
a bit later, for the regulatory authority to crack down on non-compliant firms, on rogue firms, on criminal firms, on firms that are otherwise violating the terms of service or the law or whatever, all the regulations. What's happening here now is that as soon as a firm is merely accused, whether the
Mm-hmm.
accusation has merit, whether it's malicious, whether it has any foundation, is irrelevant. As long as that accusation leads to an investigation or inquiry process being started, the
Okay.
firm is essentially suspended from operations without being officially suspended. And how it's suspended is if you've got clients that you need to service
Mm-hmm.
who've contracted you for any form of armed response, armed guarding, tactical intervention. Pick any of the subcategories out of the very long list of armed security services any security firm might render, whether it's specialized or more general. You can't do that now because as long as you're under investigation, you can't issue any firearms to any of your security officers at all, meaning you can't
Mm-hmm.
serve those contracts, meaning you can't do the work you're being paid for, meaning you're going to lose the contract, meaning there's a very good chance that if you lose all of those contracts, your firm's probably going to shut down. And now the
Yes.
onus is on you to try and expedite that investigation, maybe even interdict it, go through legal processes, etc. It becomes an untenable, unaffordable, and impossible situation to deal with, and companies are going to close down. That is the ultimate consequence of this sort of thing.
Quite scary.
Yeah.
I see that they are intending on planning limitations on security officers carrying firearms in public spaces. Um, unless they meet certain specific, much stricter criteria. So, are there potential benefits to this restriction? And how could it affect their ability to respond to threats? I'm thinking public spaces like malls and schools and residential complexes, taxi ranks, churches, parks, sports stadiums. How could that affect their ability to respond if they're not allowed to carry a firearm?
it'll effectively severely diminish or outright nullify their response capacities or capabilities. And here's how it would work, right? So I see no benefit or upside to it at all. The public spaces mentioned are taxi ranks, cemeteries, parks, shopping centers, restaurants, hospitals, and a couple of others, right? So no armed security officer is allowed to possess a firearm in any of those public spaces at all, unless exemption is applied for to the authority under the following paragraph. I think that was paragraph R that the restriction was in, and then paragraph U is the one under which you would apply for exemptions. And to apply for an exemption is you have to essentially prove that there's no other alternative than having the firearm. You have to submit a full risk assessment, which would be an impossible thing to do. If you have to submit a full risk assessment for every single client that contracts you for an armed response service in every single neighborhood that you contracted in, it becomes undoable. And this is the thing, right? So the officer might not even be in the mall or in the public park or around any, and it's not limited to that. It says any other public spaces. Does a public road count? This is the thing we don't know. So if the officer transits through that space, if he stands off in that space, or if he's responding to a situation in that space, he's not allowed to be armed unless the exemptions have been applied for and gained. So the authority must approve the exemption. Now, there are 10,000 firms out there that might have to apply for thousands of exemptions per firm. Do you think the regulatory authority is going to be able to process all those exemptions? That's the other question one has to ask. But anyway, let's not try to bring logic into this. So essentially, it means that your armed response company may very well be prevented from supplying an armed response service. Especially, let's say you're a restaurant. You've applied for an armed response service. It's your restaurant. You're the tenant or the owner. You have a contract with a private security firm to give you a service. The regulator now says no. Members of the public frequent your establishment unless the firm has submitted a whole bunch of documents saying that you need them to do this work. They can't supply the service. That's essentially what they're saying. It's the same with malls. You're a shopping complex. You want a tactical intervention team on standby. You might not have armed mall security, but almost every shopping center I know of has a tactical intervention team standing by on-site or off-site to intervene, usually outside of the mall, should they get hit by people. We'll get to more of that later, but that's then no longer possible unless the exemption is granted. So this would essentially kill any form of armed response service or armed security service in any public space. And let's be honest, if a mall is classified as a public space, but it's private property, how does that already brings it in conflict with other legislation definitions. By the way, there is a lot of conflict in this piece of regulatory law with a whole bunch of other laws. But yeah, more on that later.
Just as you go into it, it sort of just gets better and better, or maybe worse and worse. Because after talking about the firearms now there's also some ambiguity as far as ammunition limits are concerned. The amendments will limit the security officers to what is referred to as a reasonable quantity of ammunition, but it lacks a clear definition. So, I mean, that's clearly a problem waiting to happen. If we look at it in practice, what sort of problems do you foresee with that? And are there any unintended consequences that it could have for the compliance or the use of when an officer needs to respond to a force situation?
So here's the interesting thing, right? There is no definition or quantification of what constitutes a reasonable amount of ammunition at all. It just says an officer shall not be issued more than a reasonable quantity of ammunition. You go, right. So let's say if for the average armed response guard driving around the suburbs, if he just has 2 spare magazines for his pistol, he's walking around with about 45 rounds of ammunition on him, give or take, right? Is that reasonable? Is it unreasonable? And if that's reasonable for his context, and this is the thing that I'm sorry if I'm a bit less professional today than I usually am, but the South African private security industry operates in an extremely broad array of operational contexts, geographically, considering climate, location, local population, local threat and risk levels, all this sort of nonsense. So what's reasonable in one context might not be reasonable in the next. I mean, if you had to go to a mine security firm's tactical team, and these are the sort of guys that get hit by hard criminal syndicates and zamazamas. I mean, there's stories in the news of mine security getting involved in shootouts with 100 to 300 zamazamas and the shootout lasting hours.
Yeah.
And you say to a guy like that, well, I think it's unreasonable for you to carry 60 rounds of ammunition on you. And he's going to laugh at you and say, well, that means I've got one magazine in my rifle and one spare magazine on my person, and that's all I've got, you know. Whereas if he carries anything remotely close to a reasonable amount of ammunition for his specific work context, you might go, gosh, anything under 300 rounds for this guy is unreasonably little. How's this quantified? And here's the sad part about this. The Private Security Industry Regulatory Authority is milking at least R500 million a year, at least R500 million a year out of the industry, right? Probably more than that, maybe double that. They add no value to the industry they regulate at all, no protections. They just nail them with fees and with fines for whatever non-compliance they decide to fine on the day. And now they're busy trying to kill the goose that lays the golden egg for them every year by regulating this type of nonsense. And I don't think it's because they understand what they're talking about, to be honest.
They certainly are going about it in a proper way, because the next one is on non-lethal weapons. So there's now a proposed ban on tools like rubber bullets, tasers, tear gas, water cannon, etc. And as it stands, we now know from experience that the SA Police Service is not able to assist in riot situations the way it is supposed to. We lived through, what was it, 2021, with those massive riots. So there is a definite gap in that, which security companies have been helping to fill. And now they won't be able to carry these tools for crowd control and for non-lethal threats, because not every threat requires a firearm. What are the pros and cons of such a ban if you consider the need for proportional force in many such situations?
So it's another one of the situations where I can't give you any pros, Rian, but I can give you a very long list of cons. So it gets worse, right? So they mentioned tear gas. Tear gas is regulated in South Africa by the Tear Gas Act of, I think it's 1962 or 1968. This essentially means that only the South African Police Service have access, or the state authorities have access to tear gas. You as a private entity do not have, as far as I'm aware, access to tear gas at all. So now my next question here is, are they trying to ban pepper spray for security officers? Is that actually what they're talking about here? Then they mentioned tasers. Now, taser is a specific brand name of a, hang on, I'm going to tell you exactly what it means. Taser is a specific brand name for a conductive energy device primarily used for incapacitating people. So it is not the correct term for the device. It's a brand name term. So they've banned tasers, but not conductive energy devices. Okay. So tear gas, tasers, pepper spray, water cannons, rubber bullets, and there was something else. I can't remember, but it's irrelevant. It's all the same. You can only gain access to those prohibited weapons, again, if you apply for an exemption with a similar stack of paperwork that you need to apply for your officers being armed in public. Okay. And I think there was a clause there that Martin Hood pointed out that you need to apply for these exemptions 7 days before you intend to use them. So unless you've got a 7 days heads up of violent protest action, violent rioting, or violent strike action, you're S out of L, right? Shit out of luck. You're not going to get access to those tools that you need. And your guys are going to, your security team is going to stand there, watch people break things down and destroy it, unable to de-escalate that situation with a less lethal force application. Yes. And what is at a very high risk of happening then is that the riot, the strike, or the protest action is going to continue escalating to the point where innocent life then becomes under threat, or the life of the security officer standing off at that point, and they're going to be either obligated to then respond with lethal force, which is all that they'll have, meaning people are going to die, or the security officers are going to die, or innocent people are going to die, and a hell of a lot of property is going to end up being destroyed because and it's also the case of where if your looter is now halfway clever, he goes, as long as I don't attack anybody, I can loot whatever I want and no one can stop me. You know, so overall,
That's
a net
exactly.
negative. Yeah.
Okay. Then there we get to the mandatory.
Further
Yes.
point, sorry, this is actually more important. Municipalities and metros contract private security to protect municipal infrastructure and municipal land against land invasion and vandalism. These less lethal tools are vital for the protection of this infrastructure and land. What's going to happen to those municipal infrastructure land and those security contracts if this ban comes into place?
It is a very bewildering state of affairs. Mandatory medical and psychological evaluations. So this would demand annual psychiatric assessments as well as annual medical assessment for armed security officers. So I can get that maybe it can improve fitness for duty standards. But what challenge does this pose in terms of the logistics of it, the cost, the consistency? And then I also want to know, are SAPS members subjected to the same? Or is it just proposed for the security industry?
So it's just proposed for the security industry. It's one of those things that sounds really good on paper if you just read through it at surface level and don't actually apply your brain to it at all. But the moment you start just questioning it a little bit and looking into the details, it starts looking to be the bad idea it is. And one of the first problems we sit here is who is certified to carry out these evaluations, right? For aviation medicals, you can only go to a designated aviation medical examiner, which is a specialist that puts you through an internationally accepted evaluation where the same stuff is tested to known criteria. So what are we testing? Who's allowed to do the testing and do the evaluation? How is it tested? What are the testing criteria? What's a pass? What's a fail? What's acceptable? What's unacceptable? How is it measured? What is the science behind it? It gets even iffier when you start looking at psychological versus psychiatric evaluation, by the way, which not even airline pilots go through. We don't go through psychological or psychiatric evaluations at all, just physical fitness ones. So because there's a big concern about cardiovascular health, obviously you don't want your pilots having unnecessary heart attacks. So you're looking at an evaluation for security officers that on paper are more comprehensive than that of airline pilots, but where no criteria is stipulated at all. So this was sucked out of somebody's thumb. No thought was applied to it. Yeah.
So basically, after they've now been disarmed and hardly capable of carrying out their duties, they must do these tests on a yearly basis, and the costs will obviously spiral down to the customer. Okay then. So maybe it's time for handcuffs now. This one really got to me. Reclassification of handcuffs as weapons that require registration to boot. So this obviously adds another tremendous administrative layer to the whole process. But does it improve oversight in any way? I mean, what use can there possibly be to reclassify handcuffs as a weapon?
I can think of no use for it at all. Here's my other question. Do handcuffs come with serial numbers? I don't know. I've never really looked.
No.
Some might, some might not.
I have yet to see handcuffs with a serial number.
Okay. So that answers that question. Does this mean that to register your handcuffs with the authority, let's say you've got 1,000 handcuffs, do you now have to have serial numbers engraved on your handcuffs at your cost? How do you register them? Do you have to submit some sort of list or register? Is there a registry in which you book them in and out? What happens if your handcuffs get stolen or lost? Is it a reportable incident? What if they break? Like, what is the rationale behind this, and how is it enforceable? And how, yeah, it's yet another laughably irrational requirement in an ocean of laughably irrational malicious requirements in a single piece of regulation. Well, regulatory amendment proposal, blah.
Well, then let's get to probably the standout one of the lot for me, in any case, the one that really caught my attention. Every security business must install a device, a tracking device, on every firearm that it owns. And this is to be installed by a service provider that is authorized and approved by the authority. So, are there even such tracking devices in existence? If so, what cost effect are we looking at? And what sort of bottleneck? Because they don't mention, from what I could see, they don't mention service providers. From what I read, they mention service provider, which creates the impression that it might be one service provider. I mean, obviously, that's open to interpretation, but it certainly looked like that. What sort of problems can that create if there are such tracking devices actually available? I mean, we are talking a lot of tracking devices.
We're talking about a lot of tracking devices. Let me start at whether or not these things even exist. And I did a bit of an investigation, and I found some tracking devices paired with some sort of smart holster, but it looked to be in very much a concept phase. And whether or not it even works or is applicable or is even desirable, I don't know. So as far as I can tell, this technology doesn't exist, is not commercially available, is certainly not commercially available in South Africa. We assume it would be an electronic tracking device. We don't know what criteria it needs to satisfy. What is it actually tracking? What's it supposed to keep track of? And how is it supposed to keep track of it? What are you supposed to do if it inevitably fails or breaks? There's a whole bunch of information completely lacking. And I mean, it's literally just 2 sentences in the regulation that have humongous implication in the sense of, well, this is impossible to comply with. It doesn't exist. Does that mean we can't issue firearms at all?
Well, exactly.
It's you make up a piece of technology, doesn't exist, compel for all firms to install it, give no criteria about it. Also, these regulations further burden firms with additional registers. It have to keep additional administrative processes pertaining the administration of their firearm stocks. What is the point of burdening them with this massive paperwork burden and then an electronic device that is supposed to track the same stuff?
So the broader impact of all of this, if we consider that there are currently about 2.5 million registered private security offices in South Africa, and less than 150,000, I think, SAPS members, it's a fact that countless millions of citizens and probably, well, tens of thousands, if not more, businesses depend on private security for their safety. I mean, even city councils, etc. So do you believe these proposed regulations could destabilize the industry? And what would the knock-on effects be on the safety of the wider population of citizens in South Africa?
It definitely would. I think it has the potential to destroy the industry entirely by burdening it with such a colossal list of completely impossible to comply with regulatory requirements. It would immediately increase the expense of compliance astronomically. It would increase the burden of compliance astronomically. It would make security firms less effective. It would make their service offerings considerably narrower. and would overall just enhance the safety and security vacuum we are in, as in that would be a bad thing. It would lead to a retreat of the private security industry from a lot of places where it's actually the only form of law and order that exists. It would leave everyone more vulnerable, every single person in the country more vulnerable. It would destroy thousands of employment positions and additional thousands of employment opportunities. And it would be a net negative to an extreme degree for public safety and national security. That's the long and the short of it.
Gideon, this whole thing makes no sense to me, to be honest. It's quite scary that somebody could come up with these regulations. I mean, I'm trying to be neutral here, but the more we talk, the more I start thinking, oh, shit, this is so problematic. So on that point, just to conclude, where you mentioned earlier that 11,000 people have already registered the objections. Where can concerned citizens raise these objections also for these changes before the 25th of April 2025?
So the easiest and fastest way to do it is Free SA. I think they're freesa.org. I'm just going to confirm for you now. They are running a public input. Yeah, freesa.org.za. They're running a public input campaign right now that you, with literally filling in a form in a couple of clicks, submit your objection. That's easy. They track it. They will do a full report on it at the end of the cycle. So they make sure that your objection gets to the right email address. Funny story. The email address in the Gazette is completely incorrect. We managed to get the correct email address out of PSIRA that you can send your written submissions to, the more detailed ones, which would be regulations@psira.co.za. And I also recommend that people make use of that, but just make sure you save your submission and have a copy of it anyway. So, because they like the state will like bamboozling you, they'll pretend like they didn't get your email or whatever. So, I'm recommend that people make use of both of those platforms simultaneously.
Okay, and just for those viewers who are not aware, PSIRA is spelled PSIRA, Public Security Industry Regulatory Authority, I think is the correct name for them. Gideon, thank you for this, what is a very worrisome discussion, to be honest, because it's a topic that can, I mean, the impact of this can be horrific in general. So yeah, for the viewers, I hope this has maybe added some insight or answered some of your questions, or at the very least gotten you worried enough that you would go to the addresses as mentioned by Gideon and put in your objection so that it's lodged. We need as many as we can on this one. Gideon, thank you so much for your time. Enjoy the rest of your weekend.
Thank you, and you too. And this is a very fightable thing. The more people that get involved, the better. Don't despair about it.
There we go. Thank you.